Famers, welcome back to Talk Fame to Me with B.Lynette, your home of the truth, the tea, and the shade in celebrity news. If you're new here, go ahead and subscribe because we don't do watered down commentary over here. We keep it real. Now, today is big. Tory Lanez is back in court August 18th for his appeal hearing. And guess what? You can watch it here live. And lucky for you, I'm bringing the stream right here so we can see it unfold together. So while that plays, let me catch you up real quick. Remember, Tory was convicted back in December 2022 for shooting Megan Thee Stallion. After that messy Hollywood party, he got 10 years. And ever since then, he's been trying every trick in the book, appeals, petitions, affidavits, anything to shave time off that sentence. Just last week, the judges already curbed him when he tried to slide in new evidence. They said, too late, too weak, denied. So today's hearing, this is the main appeal. His lawyers are arguing that the jury heard too much about Megan's trauma, that the trial was unfair, and that some details about Tory's character and music swayed the jury against him. But let's keep it a buck. Sis still got shot. Evidence still lined up, and Tory's fighting like this is about justice when he's really worrying about his ego. He doesn't want to do 10 years, period. I mean, who does, right? And while we're watching this live stream, I want y'all to think about a few shady questions. Is Tory really fighting for freedom or just fighting to save face? Why was Kelsey, Meg's ex-friend, flipping her story so much? Was she protecting Tory, herself, or somebody else? And do y'all honestly think this appeal changes anything, or is Tory just stalling the inevitable? All right, famers, let's roll the live court feed. And you already know, I'll be back with my unfiltered thoughts right after.
Live, please.
All right.
If I may please the court, my name is Crystal Morgan with Morgan Legal Services. I am co-counsel with Unite the People, Inc. and the Baez Law Firm for Mr. Daystar Peterson, who is the appellant and the defendant. We wish to begin by acknowledging the harm expressed in this case. For those that were affected, our arguments today are presented with the unwavering belief that our client, Mr. Peterson, is innocent, with the utmost respect. It's important as we would like to clarify that any display of empathy should not be considered an admission of guilt. That guilt is established in the bedrock of our criminal procedure that is from the prosecution. And in this case, that was riddled with numerous errors. That standard was not met. We believe the most compelling arguments are the testimony of Ms. Kelsey Harris when looking at the confrontation clause, prosecutorial comments in the opening and closing statements, and Brady violations that cumulatively occurred throughout the trial. To start with the confrontation clause, particularly with Ms. Harris, who was present in court and also present on the night in question with Mr. Peterson, Ms. Pete, and Mr. Smith on July 12th, 2020. Ms. Harris gave testimony on December 14th and 15th. These dates are important to note, but she only gave that testimony after asserting her Fifth Amendment rights. With the confrontation clause, what we must do is a very fact-specific analysis, and we must weigh Ms. Harris's right to not self-incriminate with Mr. Peterson's right under the Sixth Amendment to confront those witnesses. Because of this, we have to analyze this and take it step by step. So the first step is seeing if we have a testimonial statement. And this is according to Crawford v. Washington, 2004, 541 U.S. 36. These statements were further defined whether to be testimonial or non-testimonial by the High Court in Davis v. Indiana, which is found at 547 U.S. 813 in 2006. Statements are testimonial when the emergency no longer arises, when the statement is being given in response to a future prosecutorial event. So we know that Ms. Harris, when she gave her interview with the district attorney's office, was giving a testimonial statement. Therefore, the first prong is met. But the second prong is not so easy to establish. We need to determine if Ms. Harris was available or unavailable, which is a little tricky in this case, which is why we need to walk through each step. So Ms. Harris walked into court and said, I exercise my Fifth Amendment right. That made her unavailable. But when they granted her use immunity, she was thereby available again. Yet she still got on the stand and testified in a manner that was not consistent. She said, I don't remember. Or she said, I was dishonest in my interview with the district attorney's office. Therefore, because of the way she was testifying, they decided at first to take this interview, which at the time we did not have a transcript for. And they were playing portions of the recorded statement to refresh her memory that the jury heard. So at first, that was going on in her direct. Then in her cross-examination, as she continued to testify in this varying manner that wasn't the way everyone expected her to testify, they entered the entire recording into evidence. But that recording was not entered into evidence while Ms. Harris was giving her testimony. It was entered into evidence on December 16th. And at that point, this is when the defense received that transcript, which we argue not receiving that transcript was a violation of Brady. And it also was a violation of Penal Code 1054.7, Your Honors. So we have this now statement in evidence, which is a transcript of a testimonial statement given to the prosecutors. In order to get this into evidence, they have first argued that they were going to use it to impeach Ms. Harris. This is because in their opening statements, the prosecutor said that Ms. Harris was going to testify that Mr. Peterson had violently pulled her by her hair from the car. This is a fact that was not proven at trial. Ms. Harris did not testify to this. Therefore, we feel that also is one of the inappropriate opening arguments. But additionally to that, we strongly objected to the late discovery of this transcript. And it wasn't just the late transcript. There were numerous other instances that the trial attorney did object to. But nonetheless, ultimately, the court did admit this statement under both Evidence Code 1235 and Substantive Evidence, Evidence Code 770. So now it's in, and we have a very unique situation here where we have a testimonial statement. We have a witness that doesn't want to give us answers and is saying I was mistruthful in my interview only in September of 2022, when this trial was in December of 2022. So it's clear that she did not want to cooperate. She said as much on the stand, I don't want to be here today. As a result, these matters, we feel that we need to look at the reliability and the prejudice to Mr. Peterson. And as Ms. Harris stated, I didn't tell the truth. So we can't rely on these statements from her own words. And this did greatly prejudice Mr. Peterson because in that interview, Ms. Harris said, my friend and I were attacked and it was this man's fault. And then at trial, she did not verify those statements, but the jury still heard those statements nonetheless. And we know that the jury relied on these statements because during deliberations, they did ask for a copy of that transcript to further analyze it. Therefore, we feel that the totality of this circumstance really does show that Mr. Peterson didn't have a chance to confront that witness in the Sixth Amendment context. Additional errors occurred throughout opening and closing statements. Start with the opening statements. We heard the prosecutor promise that he was going to put Mr. Justin Edison on the stand, and that Mr. Edison would say that the following day, when Mr. Peterson met with him to give Miss Pete and Miss Harris's belongings to him, that Mr. Peterson confessed that he did this crime. So the jury, in opening statements at their first introduction to Mr. Peterson, heard he's guilty and he said so, and I'm going to put a witness on the stand to prove it. But Mr. Edison never testified in the trial. Mr. Edison was not being cooperative with the prosecutors. In fact, in November 28th, 2022, the court had to put a body attachment onto Mr. Edison. And on December 5th of 2022, Mr. Medesian, our trial attorney, actually filed a motion in limine specifically for this. And he stated that he was very concerned that Mr. Edison not coming to court would severely prejudice Mr. Peterson, and he urged the court to not allow such statements in opening. This motion was not granted, and so the court heard that Mr. Edison was going to testify. When Mr. Edison didn't show up due to media coverage and comments made in the trial, it was implied that Mr. Peterson was responsible for Mr. Edison not being in court with no proof of such contentions, which further prejudiced the jury. The body attachment continued at that point, and he still did not cooperate with the prosecution. We know in California, due to Hawk v. Superior Court, which is found at 42 Cal App 3D 108 in 1974. This is the controlling case that supports the contention that opening statements are confined to a reasonable good belief of what the prosecutor feels he will be able to show in the trial. Reasonable good faith, arguably, very respectfully, is not having a body attachment on a witness. The witness may or may not be trying to avoid the process. We don't know. He's just not there. And so that's all we can rely on. And ultimately, what happened is exactly what Mr. Medesian was afraid of in his motion in limine. And what Hawk warns about is that we must have this reasonable good belief in these opening statements to promise something, especially when it comes to a confession, because the jury is going to believe the prosecutor. They're going to rely on those words and have the prosecutor guide them and direct them to show why Mr. Peterson was guilty. So because of the great weight that the jury naturally gives the prosecution, we feel that these statements were inapposite to a good faith belief. Generally, a court would give a limiting instruction and attempt to cure such a situation. But in Mr. Peterson's court, no such instruction was given. There was no curative instruction for these opening arguments.
Let me ask a question here. So are you arguing that any time a witness is subject to a body attachment, that should be, that any reference to that witness should be off limits in opening statement?
I think that the prosecutor should be extra careful in such a situation because they're going into this knowing that that witness is not cooperative. So I think that if they say that they hope to produce such a witness, that perhaps would be enough. But here, there was just no hesitation. And I think it's especially true in the case of the evidence that we're dealing with Mr. Peterson, that it was a confession.
And so what was the evidence or indication that the people did not have a reasonable good faith belief that they would be able to produce Mr. Edison at trial?
We actually have no proof of the district attorneys ever speaking to Mr. Edison. The defense was never provided of a copy of any interview that they conducted on this witness. We have no physical evidence. All we have is an email from the district attorney in this case that said, I didn't disclose this and I meant to disclose it, but we are going to call this witness who will say that Mr. Peterson confessed to him. So I honestly, despite my best investigations, we cannot find where this statement came from. We cannot ascertain the veracity of these statements. That's why I think it's inappropriate. I don't think it's always inappropriate, but in this case, with these particular facts, I do feel that it's inappropriate. And there was also problems in closing arguments, which contained inaccuracies, and it presented the evidence in a way that misconstrued the actual results. Here, I'm specifically talking about the DNA evidence. So we heard the prosecutor close the case by telling the jury, don't be fooled when we hear that Mr. Peterson is excluded. But that's not exactly what the evidence said, which they had in their possession. I feel that statement really misled the jury. It may have confused them. It played on their emotions. And we know that that's not appropriate in closing statements. And in order to really understand the weight of that statement in closing, we need to understand what the evidence was that the district attorney had available to them. So as shown in our brief, in our reply brief, as for the magazine, there were 4 DNA profiles discovered on the magazine, none of which that were Mr. Peterson. Therefore, he was excluded from the magazine. As far as the firearm goes, they also found 4 different samples, one of which was a 90% male contributor. But Mr. Peterson was excluded from being that 90% contributor. Therefore, telling the jury, don't be fooled when you hear he's excluded is just not quite as the evidence showed. And to illustrate this, I want to clarify some key terms in science. So inconclusive, we heard in trial testimony, means it's not positive, it's not negative, it's just a neutral result. But it's not quite as simple as that. Actually, according to the scale of a likelihood ratio, which was in the discovery and presented at trial, likelihood ratios are the percentages. And we did not hear any percentages in Mr. Peterson's case, even though this evidence was available to the prosecution. This evidence was only given to defense upon our expert witness's request. So we did receive this evidence late. So this evidence was not presented in trial. It was presented in the motion for a new trial. But what we can see is that likelihood ratios that are 0, 0.01 and below are considered to be excluded. Likelihood ratios from 10,000 to 999,099 are very strong, very strong support to the prosecution that this person did leave DNA on this item. And then above 1 million is very strong. We found in the DNA evidence that they labeled Mr. Peterson's LR to be inconclusive and uninformative. And uninformative, according to this scale, is an LR of 1. Therefore, Mr. Peterson had an LR of 1 in a million that his DNA was on this firearm. And with that fact, it is actually marginally more likely that another member of the African-American population touched this gun over Mr. Peterson, which the jury did not hear. The jury heard the district attorney say, don't be fooled. But there's also no proof that Mr. Peterson did anything to fool anyone about this evidence. He presented his defense. It was their testing. We went off of what their testing said. So I just think that that is a very strong contention. People v. Berryman in 1999, 21 Cal 4th to 50 is a significant California Supreme case that addresses the standard for overturning a conviction due to prosecutorial misconduct. It's a principle, basically the key outcome of that case was that we must show that this misconduct materially affected the outcome of the trial. And it did, because if our jury had heard that Mr. Peterson, maybe 1 in a million, touched the gun, I believe that would have been enough to tip that scale and show reasonable doubt for them to find him not guilty. The jury just didn't hear that. They heard that Mr. Peterson hoped that they would be hoodwinked in the alleged closing arguments. So due to these statements and the misconstruing of the evidence, we feel that that was a very significant issue in the case. And finally, we feel that the Instagram post, as we discussed in our opening brief, this was a Brady violation. This post was given not only late, but it also was not redacted. It was riddled with hearsay. This post is significant as it also implies a confession, because what we have is actually various people posting, and this was in September of 2020, and they were posting that people were saying that, oh, well, if Mr. Peterson didn't do it, then Ms. Harris must have done it. And Mr. Peterson's social media manager commented on this post, no, they're not. And so that was used as an admission. But many celebrities don't run their own social media accounts. This is significant because, number one, had that discovery been given timely, we could have provided the statement that was provided in the motion for a new trial by Mr. Farias, stating that he is the one who runs Mr. Peterson's social media account. He made that post, and he didn't ask Mr. Peterson before he made that post. So that right there, we could have, if it was not late, presented a defense. But because we didn't have that, we were caught off guard. We were always in a position of reactive instead of actually being able to produce a good defense on this case. The Brady rule provides...
Let me just ask one question at one thing you said.
Yes.
Were there requests for redaction of that exhibit or of the post?
I believe there were, yes. Mr. Medesian did do a very good job objecting throughout the trial. We also must remember that Mr. Medesian only took over this case 2 weeks to a month prior the start of the trial, because the first trial attorney did withdraw and was permitted by court. Yet, I understand the court allowed that, but as an attorney, that's a very big feat to step in the shoes of another attorney so close to the trial. So I feel that all of these arguments we're discussing today, we do need to take that into consideration overall with them and think, in the alternative, this could be an effective assistance of counsel. But the Brady rule provides that this exculpatory evidence must be provided to defense whether or not a request was made. The suppression of this evidence, it doesn't matter if it's willful or accidental, so long as it was suppressed, then that is the problem right there. And I do have a 3-part test, which is found in the United States Supreme Court in Strickler v. Green, which is 527 U.S. 263 in 1999. They reiterated the 3 components of a Brady violation. The evidence must be favorable to the defendant. Here, yes, the evidence was favorable. Had we gotten that Instagram post earlier, we could have brought that declaration in trial saying Mr. Peterson doesn't run his own social media accounts. Had we gotten the DNA evidence and not had to request that from the prosecution, we could have prepared for a better DNA argument, having the full picture. Had we had the testimony, the transcripts from Ms. Harris's interview, we could have countered that. We could have questioned her on cross about her interview. We also likely did not get fingerprint evidence on time. We did not get, and the fingerprint evidence actually showed that Mr. Peterson's fingerprints, were not found on that weapon. Currently, we are attempting at the Superior Court to have them run the serial number to identify the owner of the weapon, which was not done. And we are also attempting to retrieve either a recording or a transcript of one of the key witnesses' testimony. One of the key witnesses in the case, Mr. Sean Hawley, who gave testimony. We're attempting to get a copy of his 911 call.
Wait,
which
you said Sean Hawley?
Sean Kelly.
Oh, okay. I'm sorry.
Yes.
I thought you were referring to counsel who's female. Okay.
Yeah, no, very close. Yes, Sean Hawley was the attorney. Sean Kelly was the witness.
Okay, got it.
Different spellings also. So obviously we can see that this is favorable. The second question under that three-part analysis with Strickler was it suppressed willfully or accidentally? Yes. This evidence was suppressed. All of these different pieces to where Mr. Medesian said, I feel like every day I wake up and I have an email from either the night before or the morning of saying, oh, we missed giving you this. And very respectfully, I say that. And the final component of this three-prong test is, would it have changed the outcome of the trial? Yes. Absolutely. If our jury could have heard the full picture, the full accurate picture of just the evidence being laid out as it was, without these don't be fooled and, late discovery, I feel that it would have really tipped those scales to reasonable doubt to find that Mr. Peterson was innocent. And that's why today we humbly, humbly pray for exoneration of Mr. Daystar Peterson.
Thank you very much.
Thank you.
Morning, Your Honors. May it please the Court, Deputy Attorney General Michael Keller for the respondent. I want to begin by discussing the compelling nature of the evidence in this case. Within minutes of the shooting, the police found the gun that was used under appellant's seat. There were only 4 people in the car. Pete and Harris both identified appellant as a shooter. That first ID occurred within minutes of the shooting when Harris sent a text to a member of Pete's security team saying, help, Tory shot Meg, 911. Harris again ID'd appellant as a shooter in the recorded statement, and we can get to that in a moment. And Pete identified appellant as a shooter both before trial and at trial. Neither of them ever suggested that anyone other than appellant fired the shots. Now, there's 3 times in which appellant tacitly admitted being the shooter. The first is hours after the shooting, appellant made a recorded call to Harris stating that he didn't even remember what they were arguing about, and he wanted to know the hospital where Pete was being treated. He blamed alcohol for the quote unquote shit that he did. Now, the second one was later that day, appellant sent a text to Pete, to the victim, and that text was preserved. In it, appellant said Pete would probably never talk to him again, that he was sorry, and he blamed again the alcohol for the quote unquote shit that never should have happened. And then the third and final is the verified Instagram post that I'll also get to. Now, appellant's assertion is that he really wasn't accepting blame for having shot Pete, but for causing a rift in a relationship between Pete and Harris. And that's just nonsensical. First of all, Harris told the appellant she was at the hospital waiting for Pete. So if there had been a momentary rift that night, it was over because she's now at the hospital waiting for her friend that she's known for 7 years to be released and checking on her. Second, appellant didn't apologize to Harris, but yet he anticipated that Pete would never talk to him again. He was clearly accepting responsibility for something very big, something that applied to Pete, but not to Harris. And as appellant said, he couldn't remember what they'd argued about. He wasn't accepting blame for anything he said. Finally, appellant said that he expected to receive backlash once word got out. Now, backlash for causing a rift makes no sense, but backlash for shooting someone does. The evidence in this case was compelling. Turning to a few of the issues that have been highlighted here today, I'll start first with the Instagram post. This was appellant's verified account. And a few times today I heard opposing counsel mention Brady, but Brady was never mentioned in appellant's opening brief or the reply brief. It can't be raised for the first time at oral argument. And frankly, it has no application here because the things that were turned over were inculpatory, not exculpatory. So when it comes to the Instagram posts, they were turned over upon realizing them, and there was no, many of the case, as you'll see in the respondent's brief, many of the claims that appellant raises are forfeited by a lack of objection at trial. And one of the things Your Honor asked is, did counsel ever ask for redaction? I don't see that anywhere in the record when it came to the Instagram posts. In fact, counsel didn't even object on the discovery basis. The objection was solely based on foundation. So discovery doesn't work for appellant on appeal. And as to foundation, the question really is whether or not there is an inference that can be drawn that a statement was made by a party. If so, it falls under the party opponent exception to the hearsay rule. And in this case, it's a verified account. And the fact that there may have been somebody else who had access to it to respond and may or may not have had permission, that would all go to weight, not to admissibility. Turning to the issue raised about the Harris recording.
Let me ask a question about the Instagram post before you move away from that. And I guess the question is, if there were some sort of error in admitting that post, what would your argument be about as to whether that was prejudicial or not?
Yeah, it certainly wouldn't be prejudicial, Your Honor, because first of all, at trial, it came out about these other aspects. In other words, do we know for sure whether or not this was appellant personally authored or approved of it? There's some question about it. But what we do know is he did send the text. What we do know is he did make the recorded phone call. Like, that's his voice. So, and by the way, I would say that on the Instagram post, the post, all it said was Harris didn't do the shooting. He didn't say, I did the shooting in that. So it's no more incriminating than the other admissions that came from his phone in a text or in person in a voice recorded call. So turning to the tape recorded statements that were made by Harris to impeach her as prior inconsistent statements. When she was on the witness stand and made a number of inconsistent statements, the prosecution impeached her with those prior statements. Much of the recording, pieces of the recording came out during that period of time. While she was still on direct exam, the prosecutor announced a desire to play the entire recording at a subsequent time. And that was that's 5RT 3664 through 3665. Now, this puts the defense on notice that the entire recording is going to be played. The defense has an opportunity to object to it, to portions of it. and counsel doesn't do so. Counsel instead has an opportunity then to cross-examine on anything and everything that's in the recording because counsel knows that the entire recording is going to come in. So a confrontation clause claim just doesn't lie. And then I would add that on top of it, Harris wasn't excused as a witness. At the end of Harris's testimony, I see nothing that would preclude Harris from recall. So a confrontation clause is for when the defense doesn't have an opportunity to cross-examine a person on it. Harris testified, although Harris initially took the fifth, Harris was given immunity, subsequently testified. So the confrontation clause just does not work on appeal. And lastly, I'll turn to the allegations of prosecutorial misconduct. On that, again, these are forfeited claims. Objections weren't raised. Your Honor asked a question about how do we know on good faith, bad faith versus, there was a body attachment. You have a prosecutor that is, because the trial court did inquire into it, and the prosecutor said that the witness was under subpoena, and the prosecutor said they had a good faith. That's a judgment for the trial court. Now, I would note that if the defense counsel wanted more information about it, that was the time to raise it and to try to develop more details right then and there before the ruling as to whether or not this witness was going to be available and whether the prosecutor actually had a good faith. And the defense's failure to do so precludes the claim from being raised on appeal. And one of the things I'll note that is in the reply brief as to these allegations of misconduct that weren't raised below, the reply says, well, an objection would have been futile because it would have run the risk of highlighting the issue for the jury. That's not what decisions involving futility involve. The futility exception applies only if the record shows that the objection would have been overruled or that nothing could have been done in a curative fashion, not just that it might highlight an issue for the jury and the attorney had a tactical reason for not doing so. Unless the court has any questions, I'm prepared to submit on the brief and ask this court to affirm the judgment.
We have none. Thank you very much.
Thank you.
Any rebuttal?
Yes, briefly. Regarding the text to Mr. Edison, there was actually a motion in limine filed regarding that text. It was filed on December 12th, 2022 by Mr. Medesian. He stated that without Mr. Edison present in trial and without the foundation laid, that this text message shouldn't be admitted. That objection also was not granted by the court, but was on the record nonetheless. I've heard the people say that there was not compelling evidence, or there was compelling evidence, excuse me, to find Mr. Peterson guilty, but I argue that there was not enough evidence because we talked about the physical evidence in this case and the lack of physical evidence in this case. We discussed the variance in testimony where even today, it's still not quite clear what happened on that night. And I also want to talk about the Instagram post. The fact that Mr. Peterson didn't say, well, it wasn't Ms. Harris and it was me, that really doesn't matter. There were only 4 people present the night in question. One was Mrs. Pete, one was Mr. Smith, who was the driver, leaving only Mr. Peterson or Ms. Harris in possession of that weapon doing the acts that we're here for today. Therefore, it doesn't matter if he didn't confess. It was an implied confession because there was no question as to whether Mr. Smith or Miss Pete ever did these actions. I would like to remind everyone that Brady is willful or accidental. Brady says that regardless, the defense has a right to the evidence that's being produced against them in court. The incidents were very significant. The pieces that we were not given would have changed the outcome in this trial. For example, with the Harris recording, there also was an objection there for the Harris recording. That goes back to our motion in limine on December 5th. And in that, when there also was a sidebar as this was going on and these statements were being played to first refresh Ms. Harris's memory, Mr. Medessian did object and there was a sidebar and the judge actually commented that it's just easier this way. And Mr. Medessian said, but procedure. And the judge said, no, it's fine. We're going to do it this way today. So those objections were raised in the courts. Those weren't waived. And honestly, as far as recalling Ms. Harris, there was no body attachment. She stated, I don't want to be here. I don't want to do this. She stated, I have not been truthful. And I can't speak for Mr. Medessian. So there is no record of why or why not she was not recalled. But I feel that the people did just make a good point that it was futile. I feel that at this point, Mr. Medessian very respectfully did feel defeated. He did feel overwhelmed. He stated in his objection, I wake up every day and have an email from late last night or this morning with another piece of evidence that the people forgot to give us. And I do feel that he lost some of his steam there, so to speak. And then because of that, that's why I reminded the court that he had that very short time to prepare, and any objections that were missed should be construed as ineffective assistance of counsel. And in that, I submit.
Whew, famers, that was a lot. We just sat through Tory Lanez's appeal hearing live, and honestly, it gave what I thought it would give, desperate energy. His lawyers pulled out all the stops, but to me, it still feels like smoke and mirrors. At the end of the day, Megan Thee Stallion got shot. The evidence pointed straight at Tory, and no amount of legal gymnastics is going to erase that. But let me ask y'all, do y'all think Tory has a real shot at getting this conviction flipped, or is he just wasting time? And let's not forget Kelsey. Was she being a loyal friend, a scared witness, or just out here protecting her own back? Anywho, drop your thoughts in the comments because I know my famers have opinions. Don't be shy. Was this appeal about justice, ego, or just Tory not wanting to face his 10 years? As always, thank you for tuning in to Talk Fan to Me with B.Lynette. Make sure you're subscribed, hit that like button, and share this with somebody who loves the tea served hot and shady. Until next time, famers, keep your eyes on the fame, and remember, not all press is good press.